watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.
Hear ye, hear ye, hear ye. Supreme Court of Florida is now in session. All who have cause to plead, draw near, give attention, and you shall be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. The first case on our docket today is Snelgrove versus the state of Florida. Counsel.
May it please the court. My name is Jim Wulchak, Assistant Public Defender from Daytona Beach, and our office represents the appellant David Snelgrove in this direct appeal from his resentencing to 2 death sentences following this court's remand for a new penalty phase trial. Due to time constraints with the oral argument, we would like to focus this morning on issues 1, the denial of the continuance, issue 4, the prosecutors commenting on matters not in evidence, and issue 6, the impropriety of the death sentences, and rest on our brief on the remaining issues. Facts briefly relevant to these issues: the defendant, who was a mentally impaired crack cocaine addict, affirmatively sought residential drug treatment for his crack cocaine addiction. And after 3 months into the program, wherein he was highly successful and active participant, he was suddenly terminated from the Salvation Army drug treatment program for fraternization, which there was testimony that this is a common occurrence, so much so that most programs don't have co-ed drug rehab treatment programs. So he found himself thrown out on the street from the Salvation Army for this fraternization without any transition or without any support. And he was able to stay clean for a time, a highly impressive feat, according to the expert. And he obtained manual labor job despite the influence of his crack cocaine pushing and using cousin. However, he tragically succumbed to the irresistible craving for crack cocaine since he wasn't able to complete the drug program.
Is this on a, we're familiar with the factual background. Are you alleging that the trial judge didn't adequately weigh that mitigation?
Yes, Your Honor.
And which issue would that be?
Yes, Your Honor, that would be the impropriety of the death sentence and the lack of adequate findings by the trial court, issue number 6. And it was under this influence of the extreme mental and emotional disturbance of the crack cocaine addiction and the irresistible craving for more, which, even according to the trial court's findings, significantly impacted the defendant's thinking that these crimes tragically occurred. The first issue is the trial court's denial of the continuance unconstitutionally deprived the defendant of his opportunity to present to the jury evidence regarding his possible mental retardation. We would cite to this court a case...
Well, let's get the time frame on this. This was a resentencing, as you said.
Yes, Your Honor.
At the first sentencing, at the first penalty phase, was the mental retardation of Mr. Snelgrove an issue?
No, Your Honor.
I mean, nobody even considered, after looking at his school records, everything, that there was an issue of mental retardation? No,
unfortunately, the school records weren't very complete and didn't show an IQ test.
Basically what happened, and that's why I'm not very sympathetic to your argument, virtually on the morning of trial, after how long had elapsed from when a new penalty phase was granted until the trial started? Well, how many, was it months, years?
It was slightly over a year from the denial of the United States Supreme Court cert from the initial direct appeal.
And then the night before, the mental health expert says, you know, I think maybe he could be mentally retarded.
A couple things, Your Honor. First of all,
Is that how it happened, essentially?
Yes, but when this case was remanded for a new penalty phase, the original trial counsel for the defendant no longer worked for the public defender's office, so new counsel had to take over the case, familiarize himself with it, and like I said, the cert was denied October 20th of 2000.
Well, but did the trial lawyer ask for a week continuance? Was there a specific request for how long to pursue this?
Well, what happened was the defense counsel had repeatedly asked the mental health expert who had testified previously and administered the waste test on the defendant, repeatedly asked him, is there anything else you need? Have you reviewed your notes? Is there anything else? And he said, no, I haven't gotten to it yet. And it was only the night before trial, the new penalty phase was to begin, that he informed defense counsel that, oh, wait a minute, I'm looking at this, and he should have been administered the waste 3 test because that's more accurate and can show.
I mean, isn't it a fair reading of what really occurred is that all of the testing would not satisfy the elements for mental retardation, and then as a last straw, well, you know what? They've come out with a new form of the exam. Maybe if we do that one, we'll get a more favorable reading. Isn't that really what this boils down to?
No, Your Honor, I don't think so. The mental health expert, in reviewing his notes, realized that perhaps there was more here, and it was only the night before the penalty phase was to begin that he informed the defense counsel.
But haven't the tests been done before? Have not the tests been done before?
The original waste test had,
Right.
but not
At
the
the
waste
time-
3, which...
Wait, just a minute.
Okay, I'm sorry.
The correct test at the time it was administered, correct?
I believe the waste 2 or waste 3 may have been out by then, but they did not administer that test originally.
So you're saying they administered the wrong test? I didn't read this record to suggest that.
Well, they administered an IQ test, but the expert testified the waste 3
Well, I understand. We've had other cases, and we understand that it was changed. So really, if that's the view that folks are going to take, is that then what we do, we just wait until they come out with a new version of the test, and because of age and each year that things happen, well, maybe it'll change sometime in the future. Isn't that really what happened here?
No, Your Honor, I don't think so, because of what the mental health expert said. We would cite to this court the case of Sorge versus State, where then Judge Polston was on the panel, and in that case, on the eve of trial, the mental health expert in that case said, who had been ordered to do an insanity test previously, but had only done a competency exam, said, wait a minute, he may be insane. We need to examine that.
But now, isn't insanity a little different matter, and competency a little different matter than retardation?
No.
The whole notion in the law about retardation is that's something that's pretty stable. It's not like you just get retarded, but somebody can be sane one day and not sane the next. And so, isn't that a significant distinction?
No, because it's sanity or insanity at the time of the offense, not at the time of trial.
Well, if you're talking about at the time of the offense, I agree with that. But if you're talking about competency for trial, that's a different.
Right. Well, they had already done the competency. That wasn't the issue. The issue in Sorge was insanity. We submit insanity going to the guilt issue is the same as mental retardation going to the penalty issue.
We review the judge's decision to deny a motion for continuance on an abuse of discretion.
That's correct, Your Honor.
And you're essentially asking for a rule that rewards somebody, and it may be, if we get into post-conviction, that we see whether it was the trial lawyer or it was the last-ditch effort of them together, but that comes up with something the night before trial, and that entitles them to a continuance of indefinite length. And the rule of law on that is not satisfactory, and I'm not seeing the judge's abuse of discretion here, considering the timing, considering the amount of time before trial. And I mean, I'm sorry that if the defense lawyer had been on his expert and the expert just woke up the night before trial, that's not something that is the something the trial judge should say,
But
okay.
should you penalize the defendant
Well,
for
let's go
that?
over-
Should you deny him his due process right to a fair trial to present this
If
evidence
it's newly,
relevant?
I would say, if it's newly discovered evidence, it's one thing, and you were now alluding to whether it was a due process denial. As I understand it, the judge allowed some leeway. Did the testing take place?
Yes, the testing took place during the penalty phase
And what
trial.
was the result of the testing?
IQ of 70, which is within the mental retardation range.
And was that
During the-
contested by the state?
It was later tested by the state, who came up with a figure, I believe it was of 78. However, the jury was entitled to hear this, and what happened was...
Well, the jury heard he had an
jury
IQ
heard-
of 70.
The jury heard that, but the state attorney harped on this. But you cannot say, he said to the mental health expert, that this defendant was mentally retarded. No, because I haven't done the adaptive functioning test, and I haven't had time to do that, so I can't say he's mentally retarded. So the prosecutor pointed out to the jury time and time again, the defense expert cannot say he's mentally retarded. If a continuance had been granted, the expert could have done the adaptive functioning
And then
test, which the expert
at the
said he had severe deficits in at least 5 areas.
And was that what was presented to the trial judge?
It was presented
And
to
what
the
did the
trial
trial judge
judge for
find
a
out?
mental retardation hearing after the jury recommendation.
And what
But
did
we
the-
submit the jury is entitled to hear this. It is a mitigating circumstance
And what
under
did the
Lockett
trial
versus
judge
Ohio.
find on the adaptive functioning?
The trial judge rejected mental retardation solely, as did the state's expert Pritchard, saying that the defendant's IQ was 78. The trial judge did indicate that there were some abnormalities, some adaptive function issues with the defendant, but rejected those, which I would like to address when we get to the penalty issue.
After the jury recommendation, did the trial judge grant a 6-month continuance so that this adaptive testing can be done?
Yes. After the jury recommendation, there was a continuance is granted.
Was that before dispensary hearing or after dispensary?
Yes, before
dispensary.
Before the mental retardation / dispensary hearing. They had them both simultaneously. We would submit this is no fault of the defendant or his counsel, and while the statute and rule provide for the court to decide later to bar the death penalty on a finding of retardation after the jury recommendation, this type of evidence is highly relevant for the jury to consider, and he was prevented from considering that.
Now, adaptive functioning, Justice Lewis was asking you about the WAIS 3 and that being new. But the problem I have with this again is that, what year was the murder in this case?
2000.
Right, and the resentencing took place in 2009?
2008, I believe it commenced.
When was the first sentencing?
It was a 2002, I believe.
Just like what Justice Kennedy was saying, is that adaptive functioning is a lifelong
That's correct.
issue. And it's really mental, in my view, even though we say current mental retardation, I think that, to me, the Supreme Court meant mental retardation to reduce culpability at the time of the crime. If he had these significant deficits in adaptive functioning, so that he wasn't functioning in life, my goodness, what was someone doing for 10 years or 9 years to really look at whether that was an issue?
They didn't even look at it, just like the state's expert didn't look at adaptive functioning because of the IQ test. So they didn't think they needed to until the night prior to trial.
But it's still mitigating evidence if he can't live on his own, if he did terrible, and whatever it is, that's still mitigating evidence.
You mentioned earlier that a competency evaluation had been done. I take it that was done earlier on in the case?
That was in the case of Sorge versus State, Your Honor.
Oh, I'm sorry.
So, what were these deficits that were so significant that appeared 6 months later? What type of deficits did he have?
He had deficits in his communication ability, his ability to perform functions.
Okay, and that's what I'm saying, is that those don't just pop out of the blue and like a new IQ test. If he had deficits in communication and it would be apparent, and that's where I'm seeing this as being a last effort.
Defense expert even pointed out that the original sentencing order from the judge back in 2001, 2002 did include these, and so they were presented. But the expert hadn't evaluated these, hadn't looked at the school records for the possible onset before 18. And again, this was evidence that the state attorney harped on. So you cannot say he's mentally retarded, but through no fault of defense counsel, through no fault of the defendant, he's being punished. His due process rights are being denied. Each case, admittedly, has to be decided on abuse of discretion, and it's on the specific facts of the case. The state has cited the case of Doorball versus State, and that's clearly distinguishable. In that case, it was limited to its extreme facts where defense counsel actually caused the delay by doing absolutely nothing. This court saying that it was obvious that the defense counsel did nothing just so a continuance would have to be granted. We would cite that under the Sorge decision, it's clear that defense counsel tried through no fault of the defendant, through no fault of the defense counsel, but instead through the mental health expert, exactly like in Sorge, he was not given this opportunity to present these to the jury. The jury recommendation then is thus tainted and cannot support the death penalty. Issue number 4, the state may not inform the jury through questioning that they have additional evidence which was not presented to them which would negate the defendant's mitigation and support the death penalty. A prosecutor is prohibited from commenting on matters not in evidence, but this is precisely what the prosecutor did here.
Well, you were saying through cross-examination of the expert, correct?
Yes.
And if experts testify with regard to matters that are not in evidence, do they not?
They may base their opinion on matters not in evidence, but
the opposing side cannot ask questions that would then test what they have looked at and have not looked at?
We submit that even hypothetical questions of expert witnesses may not tell the jury that there is other evidence they have not heard. If they're going to ask a hypothetical question, the evidence has to be presented. Here the prosecutor was able to ask defense mental health experts whether his alleged admissions and demeanor about the killing to Gary Matthews, the jailhouse snitch. They asked this of Dr. Berland. They was able...
Wasn't that statement in Dr. Berland's possession?
He did not view it. He did not feel that it was relevant.
But that's what the cross-examination was about. In other words,
they should...
Wait, can we have like an orderly oral argument? I ask a question.
I'm sorry.
You wait.
I'm sorry.
Thank you. The cross-examination was about the fact that Dr. Berland just picked and chose what he was going to rely on, and the point of what the cross-examination was to say, you had this evidence about his guilt and you ignored it. Why is that improper?
It's improper because the state was permitted, at the first trial, they presented the testimony of Gary Matthews. But here, that testimony was not presented. The prosecutor is telling the jury, we have additional evidence that negates his mental health.
Let me ask you about section 921.141, subsection 1, which says in pertinent part, any evidence that the trial court decides is relevant to any of the aggravators or mitigators, of which the court deems to have probative value, may be received regardless of its admissibility under the exclusionary rules of evidence, provided the defendant is accorded a fair opportunity to rebut any hearsay statements. That's right there in the statute.
Was he given the opportunity to rebut Gary Matthews' testimony? No, because it wasn't presented here. It was not presented to the jury.
Did you attempt to present anything that you were precluded from presenting, that weren't given an opportunity
to present? They couldn't. At the first trial, if you read this...
The fact that there's something happened at the first trial does not set the standard for the second trial, okay? I don't understand, and the rules are, you would concede, would you not, that the rules are somewhat different in the sentencing proceeding than they would be in the guilt phase?
Yes.
The statute says that. And like my colleagues, I'm just having trouble understanding why an expert can't be asked about the basis for his opinions and what he considered or didn't consider, and did he consider this or that, and which are relevant factors.
What happened here was that the prosecutor was able to present essentially the testimony of Gary Matthews, which was rebutted during the first trial. That's why I bring that up. But here they weren't able to rebut that at all. The defense wasn't, because Gary Matthews didn't testify.
Well, because it was in the first trial, it was a guilt and penalty phase. So didn't Matthews testify in the guilt phase of the first trial?
Yes, Your Honor, but he presented evidence relevant to the penalty phase as well, we submit. The case law indicates that you cannot ask hypothetical questions, even of an expert, if that evidence is not presented to the jury. Here they were told there's additional evidence.
Though. I guess that's what I'm having trouble with. I can understand in a vacuum if they sort of say, well, did you consider this? And this wasn't something that he had been provided, but it was in his file, and he chose to ignore it for his own reasons. That's legitimate cross-examination.
What if a defense expert was asked, well, are you aware of Dr. Jones's report that says he didn't have any mental health issues? The state has presented to the jury Dr. Jones' mental health findings without giving the defendant an opportunity to confront that expert. This is the same type of thing here we submit, and we submit that it was error.
You can't comment on another expert, so there's another bar to that kind of situation.
You have exhausted all your time, including your rebuttal time. However, since we helped you so much exhausting your time, I will give you 2 additional minutes for rebuttal.
Thank you, Your Honor.
Good morning. Scott Browne on behalf of the state of Florida. Your Honors, the trial court did not abuse his discretion in this case when he denied the morning of trial request for continuance. And the basis for that continuance, as this court is aware, is not on the prospect that he was retarded, that he had a finding from an expert that he was retarded, but on the possibility that he might be retarded if we did some additional testing.
But isn't that the kind of information that is, in fact, relevant and pertinent in a penalty proceeding?
But certainly, Your Honor, if you take a look at it in this case, the original trial, 2002, this expert had been used by the original trial attorneys. He was long known to the defense attorneys well prior to the penalty phase. This case had been continued already at the request of the defense for 1 year and 4 months.
But wasn't it later continued? I mean, after the jury made its recommendation, didn't the trial judge then give him a continuance to do some additional mental retardation testing?
Correct, Your Honor.
And so it just seems to me that if you're going to give him a continuance at any point, that why not give him the continuance at a point when he could get the information and the information could then be presented to the jury as opposed to just to the judge?
Well, Your Honor, I have a couple of responses to that. First of all, on the morning of the penalty phase trial, there's a significant inconvenience and harm to the parties. And in the state in this case, we had out-of-state witnesses, out-of-state family members here ready to go. So when the defense counsel comes in on the morning of trial, the jury's there, we're ready for the trial in a long-delayed case based on information that, hey, he might be retarded. I think the judge made a very accommodating decision in this case, because he didn't say...
And isn't it the case that it's not unusual for there to be some delay between the penalty phase jury proceedings and the Spencer hearing?
Correct, Your Honor. In fact, what they did is they consolidated the Spencer hearing in this case with the mental retardation hearing. So what the judge has said, okay, you go ahead and test. You have an expert test him, and they even let Dr. Bloomfield testify to the obvious prejudice of the state. They had this expert who was a late addition come in and testify that Mr. Snelgrove met at least the intellectual functioning prong of mental retardation.
But isn't the problem here, and it is I appreciate, and I obviously asked questions that trouble me about what happened with the defense and the delay. But what happened then is that allow the state to cross-examine about, well, you haven't done the adaptive functioning part. And so it diminished that testimony in front of the jury. And as you know, when we talk about delay, unfortunately, these cases, as we know, we're now 2 years after the sentence, and we're just having the appeal, which is an unfortunate situation. But we're going to get into post-conviction, and the post-conviction, the defendant goes, well, wasn't I didn't delay this. The defense lawyer says, well, I didn't delay this because the expert didn't tell me until the morning of trial. So my concern is that that the state ended up using the late testing to its advantage to diminish and minimize that mitigation. Now, we can say, well, the jury would have reached the same result in this case. I mean, but the first verdict was 7-5, and this is 8-4, and that's not an over, with 2 victims, that's not a resound. I mean, it's certainly enough for the death penalty. So what is the answer to that the state used the fact that they couldn't complete their testing to the state's advantage?
Your Honor, I disagree. While there was some minimal cross-examination of the defense expert, you haven't made a conclusion in this case. The real harm, or if you will, the tactical benefit, inhered to the defense attorney. Because remember, they have a witness, Dr. Bloomfield, come in at the last minute without any notice to the state. The state didn't have their own expert to rebut his testimony. And he comes in and says it's quite likely the defendant is retarded. Now, what happens is, and this is on the undue prejudice part of the denial of the continuance, what happens is the state retains Dr. Pritchard. And contrary to the defense attorney's statement that Dr. Pritchard and neither Dr. Pritchard nor the trial court addressed adaptive functioning, he did. He did a complete mental retardation analysis. He found that he didn't meet any of the prongs to be required to be mentally retarded. In fact, Dr. Pritchard testified.
Was this at the sentencing or at the Spencer hearing?
Spencer hearing, Your Honor. So Dr. Pritchard testified that's not even a close call in this case. He had volumes of records in this case, and none of which suggest in any way that Mr. Snelgrove was intellectually or had any deficits in adaptive functioning. So what you had here was the more credible expert, as found by the trial court, who also found that he didn't meet any prong to be required retarded, comes in and completely rebuts Dr. Bloomfield, who goes, you know what, it is a close call here. Dr. Pritchard said it's not even close. There's no indication in this record in anything.
In fairness, I don't know if there are certain experts, just like the defendant has some of the same experts, the state has some of the same experts. I don't know if Pritchard sounds pretty familiar, but here's the question I have. You said that the state would have been prejudiced by a delay. I don't know how, were they asking for a specific time period?
No, you aren't. Just open-ended delay.
All right, but I'm the trial judge. I go, do you need 20 days, 30 days to do the adaptive functioning? Let's just say that inquiry takes place. Who were your witnesses that were coming from out of state?
Victims' family members, and I believe also the medical examiner, and there may have been one or two more that I don't recall.
I was going to ask you about the victim impact evidence. I mean, a lot of times the victim impact evidence is given through letters that are read, because the whole idea is you don't want to have that become a feature of trial. But did the judge ask those questions about, you have witnesses? I mean, what was the reason that the judge gave for denying the continuance?
That you have had ample time to investigate Mr. Snelgrove's mental condition, that it would harm the state. We're ready to go. The state has marshaled its resources. Your witnesses are here. The jury's ready to be picked. And now, on speculation, again, he didn't have an expert who said he was retarded, that it's quite possible he's retarded. So on that slim basis, we're going to have an indefinite continuance. I don't think you can find an abuse of discretion in this case.
So it's, because that's what it was, this idea that it's something we think might exist, and not asking for 30 days or a specific time.
Correct. It was nothing more than the request to continue the mitigation investigation, long after the original trial in 2002.
Well, is your feeling that the judge felt that this was being done for the purposes of delay and not in good faith?
The judge did not state that. I suspect that was the reason.
But it doesn't sound like, from what is being said, that was the reason, and that's what is concerning me, which is that we've got somebody who was a crack cocaine addict that the judge found and gave substantial weight to that mental mitigation. Now, the fact that I'm less impressed about the mental retardation does weigh into whether there was actually prejudice in this trial. But let me ask you about the victim impact evidence. The judge gave an instruction that said that the jury may consider the victim impact evidence in making a decision in this case. Is that what
Well, I think you're omitting what he said immediately prior to that, which is the judge instructed the jury that it is neither an aggravating circumstance nor rebuttal of a mitigating circumstance. So I think, and this court has approved that exact instruction in a number of cases.
Is that what we have now as our standard instruction?
No, shortly after this case was tried, you have changed the standard instruction. And I noted that in my brief. But
yeah.
and again, we didn't give that was the instruction that had been approved and has repeatedly been upheld as valid by this court.
Was it part of the standard instructions?
Yes, Your Honor.
On victim impact, see, I don't ever remember. The problem with victim impact evidence is that they can hear it, but it's not to be considered in rendering a decision in mitigation or aggravation. That's not us. That's the U.S. Supreme Court. So it is in this neverland which is unfortunate, for the victims, but that's how this occurs. And so if they're told they may consider it in making the decision, how do they consider it?
Well,
if it's not aggravation and not mitigate, how do they consider victim impact evidence in making a decision?
I think they're told the uniqueness of the individual, and remember, that instruction, they're told properly that it's neither an aggravating or mitigating circumstance. So I think what it does is it just recognizes that we're here because Mr. Snelgrove chose to murder two individuals, Glenn and Vivian Fowler. And I think those people, the victims in this case, were entitled to at least be mentioned during the sentencing of their killer. And we have that by statute and case law from the Supreme Court that that's entirely proper. So, again, I think the trial judge in this case repeatedly, Kearse v. State and Hernandez, has approved this very form of instruction. And that the trial court didn't, Your Honor, just say, well, you may consider it in your verdict. He said prior to that, immediately prior to that it's neither an aggravating circumstance nor rebuttal of a mitigating circumstance in this case.
How long had the new penalty phase defense attorney been representing Mrs. Snelgrove?
I don't have that exact information, Your Honor, but I believe it was a substantial portion of time. I believe they were the ones that requested the original continuance. There was at least a year and four-month delay.
So he was newly appointed, but he had a year and
Well, I don't think he was newly appointed. I would dispute that fact.
That's what.
We may quibble over what is newly appointed. I don't think it was a case where...
That's why I wanted to know how long it was so we could determine how long it was.
Your Honor, it was well over a year from my recollection of the record.
So he had a chance to observe his conduct, demeanor,
yes, Your Honor.
Talk with him and interviewed him.
And again, this is Dr. Berlin, who is not a recently retained expert. In fact, I pointed that out in his brief. He suggests that Dr. Berlin just newly talked to Mr. Snelgrove and thought he was retarded. No, he was reviewing his notes from the original penalty phase and decided,
was there anything at all suggested at all in the original penalty phase?
No, Your Honor, absolutely not. And again, he has a history
and so what did Dr. Berlin base this new possible retardation on? What evidence, what report, anything did he look at to make that assessment?
The only thing Dr. Berlin did was he looked over his original notes and the original weights, and he goes, there's something called a Flynn effect, which I'm sure this court is aware of, that is much disputed by many, particularly by the state and various experts, but it's the increase in the general population's IQ of about 0.3.
So he had he had an IQ test that he looked at and said, if you apply in effect to this, that he might be retarded.
There's a
Is that what
possibility
we're
he could
saying?
fall in the retarded range, but he wasn't even conclusive in his. He just says you better go test him because there's at least a possibility. So that's where the trial judge is confronted. Remember, he's there with everyone ready to go, witnesses, and at the morning of trial, he's possibly retarded. You have a whole prior penalty phase. You have Dr. Berlin's testimony from the prior penalty phase. That's a very slim ground, in my opinion, to request a continuance. And the state has cited a number of cases which reject the notion that at the 11th hour, a defense attorney can come in and continue to investigate mental mitigation. In Doorbal v. State, Gorby, there's also one, I think, directly on point. Granted, it's a Kentucky case, but it's White v. Commonwealth, where as in this situation, the defendant came in and said, hey, he's possibly retarded, and that court found there was no prejudice because he could present his low IQ scores anyway to the jury and argue its effect. So again, I argue...
Would the defense, since we've gone through this exercise, we had the continuance and we got more information about retardation, is the defendant now precluded from filing a motion saying that he's mentally retarded?
Yes, Your Honor. We have findings. Again, the judge had a full and fair mental retardation hearing in this case, and the judge found it wasn't even a close call, and it's not. And contrary to what defense counsel asserts, not only the state expert, but the judge went through each prong of mental retardation, and Mr. Snelgrove didn't meet any. And Dr. Pritchard had a stack of documents. I submit that the real harm, if any, was the fact that the defense had an unlisted, undisclosed expert come in at the last minute to testify he's quite likely retarded. I think that actually turned out to the defense counsel's benefit in this case. And you cannot find on this record an abuse of discretion. And briefly on the other issue mentioned by defense counsel, in this case, the defense presented Dr. Berlin and another expert, Dr. Edwards, on addictionology, I believe. And these two experts relied upon a wealth of information, most of which never were introduced during the penalty phase. So what the defense argues now is that we can rely on all this material, but the state can't ask us really what we relied upon or chose not to rely upon. And that's not really the proper bound limits of cross-examination. The prosecutor had a good faith basis for asking these questions. I mean, you don't have to go further than your original opinion in this case. It lists the facts that supposedly the prosecutor just inserted into this penalty phase. Mr. Snelgrove hid bloody clothes up in the attic. That was one area of inquiry. And Mr. Matthews did testify during the original trial. And contrary to defense counsel's assertion, there were no details concerning Mr. Matthews' testimony that were introduced, although I submit that would be proper. What happened was the prosecutor said, did you consider that Mr. Matthews' testimony? And Dr. Berlin just said, no, he's a jailhouse snitch. I don't consider that reliable. But Dr. Berlin relies upon all kinds of information, like the only evidence supporting this so-called chronic psychotic disorder that Dr. Berlin found was the wife of a long-term friend. So that's certainly hearsay, which, again, Dr. Berlin can rely upon and testify to, apparently, but the state can't go ahead and rebut it with readily available information. And as this court has largely recognized, that's not a proper restriction on cross-examination. Now, if the state had no good faith basis for asking those questions, that would be another matter. But that was not alleged, and certainly you could simply review your opinion and go, you know what, those facts are in there. They're in the original record. And again, expert cross-examination, you can ask them, if you chose to rely on something, why did you? And if you had material like police reports and other information that show goal-directed and deliberate behavior, well, why didn't you review that? Oh, it wouldn't support your opinion. Okay. Well, according to the defense, then we can't inquire because the expert didn't want to review it. That's not the standard. And the trial court was given, obviously, broad leeway in determining the relevance and scope of cross-examination. And no such abuse has been shown in this case of the trial court's discretion. If there are no further questions, State requests that you affirm the sentences that were judged and recommended by the jury below and imposed by the trial court. Thank you.
Thank you, Your Honor, for the extra time. As was pointed out, the state used the late testing to its advantage in cross-examining the defense expert at the penalty phase before the jury. The state is complaining, well, there was no notice to the state. They came in with this 7D IQ test at the last minute. We didn't have the opportunity to rebut it. But that begs the question, if the court had granted the continuance, they would have had the opportunity to rebut that. What is the defense counsel supposed to do in this instance when the defense expert the night before the trial says he may be mentally retarded? Are they supposed to just ignore that? No, they have to seek a continuance. They have to get this evidence to present to the jury. It is relevant.
Let me ask you this. Did Dr. Berlin have anything different? He testified in the original penalty phase,
Yes.
correct? And so what did he have at this point, the day before trial, the day before the new penalty phase, that he did not have at the time of the original penalty phase?
Just his mental processes in re-reviewing his notes on the original waste test, a flag went off saying, oh, wait, he could be mentally retarded. We need to get him the waste 3 test. And indeed, that test did show that he met the first prong of mental retardation, which would justify additional testing and additional examination for the adaptive functioning test. Regarding the victim impact instruction, yes, the jury was told that victim impact evidence does not relate to aggravating or mitigating circumstances, but they were also told, you may consider this. So the jury was left with the mistaken impression they can weigh aggravating circumstances, they can weigh mitigating circumstances, and they can weigh this additional victim impact, the relative worth of the victim, in considering their verdict.
What do you think a jury should do with victim impact? I mean, the United States Supreme Court has certainly said that it is relevant information that can be presented to a jury. They're told that it's not aggravating and it's not mitigating.
That's correct.
What do they do with it?
They are allowed to hear it under the U.S. Supreme Court general thing.
Well, when they hear it, can they consider it?
No, in Florida, we submit they cannot consider it because in Florida, it's limited to the aggravating and mitigating circumstances.
So what's the purpose of hearing it? That's what I want you to tell me.
That, Your Honor, in studying these cases really is beyond me. I represented another death penalty case where a trial judge asked the same question of both parties. He didn't know what they were supposed to do with it. But the U.S. Supreme Court says that when you're looking at the defendant's quality of life, his upbringing, that the jury should be able to hear, they should be able to present what the victims did.
Well, there was the proposed instruction by the defense lawyer that is
Yes.
the instruction that we
which was
adopted.
ultimately approved by
So
this
that's
court.
what you're suggesting.
That cleared up any misconceptions that the jury could possibly hear. What was the harm in giving it? The harm in giving it was the state didn't want it because the instruction they got told them they could consider this. We submit also that the sentencing findings by the court were inconsistent. One breath he's saying the drug addict and craving significantly impacted his thinking at the time of the murders, but then later said the defendant simply made a conscientious decision and chose not to conform his conduct to the requirements of the law. Inconsistent.
Okay,
We ask this court to reverse the death sentences in this case. Thank you.
We thank both of you for your arguments. We now move to the second case on our docket, Krawczuk versus the state of Florida, and I apologize if I mispronounced the appellant's name.
Good morning. May it please the court, Suzanne Keffer, Chief Assistant CCRC-South on behalf of Anton Krawczuk. We're here today on the appeal of the denial of 3.850 relief after an evidentiary hearing. And the central issue before this court is whether or not Mr. Krawczuk's waiver of mitigation was knowing and intelligent.
Can I could you fill me in on the incredible delay in this case? When was his death sentence affirmed?
The death sentence was affirmed
1994?
Your Honor, yes.
And when was the first post-conviction? I mean, this is the first, we're here today, 17 years after his conviction was affirmed, on his first post-conviction motion?
Yes, Your Honor, that's correct.
Do you have any explanation? I'm going to ask the state for this terrible delay. I mean, if your client's entitled to relief, it's terrible.
Yes.
But for the state of Florida, it's terrible.
I understand, Your Honor. I don't know that I have a specific answer for you. I came into this case in 1998 when I first started working at CCRC-South. I know that there was extensive public records litigation before
Did you say 1998?
Right.
That's still pretty.
I understand, Your Honor. I know that, I'm just saying from my perspective, there was extensive public records litigation that was going on. The public records law had changed some
He pled
during
guilty.
that time.
He pled guilty, and
That's correct.
And he
pled-
waived penalty phase.
Right.
Evidence.
That's correct. He pled guilty, and on the same day, he indicated his wishes to waive penalty phase presentation of mitigation. What is not in this record is he did not at any time prior to that waiver instruct his attorney not to investigate. In fact, he was participating.
Didn't he tell the attorney she couldn't talk with his family members?
No, Your Honor, that's not in the record. That's not clear in the record. And in fact, the lower court found that he made no unequivocal direction to his attorney to that effect. The evidence that is in the record is his trial attorney indicated he wasn't big on having his family involved, but in fact never said, do not speak to them, never instructed his family not to speak to the attorney. In fact, two of his family members, his mother and his grandmother, prior to the waiver, sometime prior to the waiver, because I believe it was shortly after she was appointed, contacted the defense attorney and spoke to her. She had their information. She had their telephone numbers. And at that time, because they were simply asking about access to visit him at the jail, she did not speak to them at all about any other information. It was very short conversations, I believe less than 6 minutes. Never contacted them again.
Well, is the standard here, because he waived mitigation, whether if this investigation had taken place, whether he still would have waived mitigation? Is that how we evaluate it?
Well, I don't think that this court has ever imposed that standard on the defendant. Looking at this court's cases, specifically Farrell.
I mean, again, you can't get, you waive mitigation, and now you say, well, there's other mitigation. You just don't get a new penalty phase. Don't you have to show that the waiver would have been different if he had this information?
Well, I think you certainly have to show that the evidence that's now been presented that should have been investigated would have been prejudicial and would have made a difference to the jury.
No. If somebody, I don't think so. If somebody is waiving mitigation, and I thought we had some cases on this, that you don't get another bite at now putting on mitigation unless you can show that your waiver was not knowing and intelligent. And this was a pre-Kuhn case, was it not? Okay, so did he testify that he now would like to have a penalty phase where he would put on mitigation?
He didn't testify, but I think that the presentation in post-conviction, and I don't think there's a requirement that he testify to that. I think that certainly...
Do you think we would give a new penalty phase and then have somebody go, I still don't want to put mitigation on?
No, I mean, I understand that concern, Your Honor. I understand that concern. I think, however, I don't think there's a requirement that he testify. However, if this court is looking at that, which it's not clear in Farrell that that's what this...
Does he want to be pursuing this appeal?
Yes, Your Honor. He was willing in post-conviction. Like I said, he never instructed his trial attorney not to investigate. There certainly is information in the record without his testimony that he would go forward with this at this point. I also think it's clear in the record and at the actual penalty phase, he wavered on not presenting. He allowed after instructing her not to do anything, he then allowed his trial counsel to cross-examine one of the witnesses. Interestingly, the cross-examination that he allowed, I think, went to the culpability of the co-defendant. He was cross-examining somebody about items of evidence that were found in the co-defendant's room in the residence that they both lived at. Also, there was, on the record at the penalty phase, that he was not opposed to mitigation, that there was just certain portions of a doctor's report that he didn't want put in. That doctor's report was only with respect to competency and sanity, and no other findings were made with respect to mitigation. However, he did indicate, with respect to that report, he would agree to having portions of it come in because everything else was against him. So there are indications in this record that he would have been amenable to the presentation of mitigation had he been fully and appropriately advised of what was available to him.
Is State v. Lewis, is that your best case?
I think there's a line of cases.
Well, what are the, okay, that's what I want
court.
to understand. We have cases where we allow a defendant to waive mitigation. You didn't argue on direct appeal that the inquiry of the trial judge was inadequate, did you?
Well, I was not the direct appeal attorney, but I think, of course,
argued.
during direct appeal, I think there was a challenge made to his waiver based on the fact, I think that he was taking medication for depression at that time.
Affirmed.
Correct.
Okay, so now, what do you have to establish in post-conviction to show that the waiver was not knowing?
To show that the waiver was not knowing, we have to show that counsel failed to investigate possible mitigation, present it to Mr. Krawczuk, and explain to him what was available. And we have done that.
And if we show that there was if you are able to establish there was deficiency in defense counsel not fully investigating, then what is the prejudice? How is the prejudice prong evaluated in this situation? Isn't it logically that he, just like in a guilty plea, that he would not have waived mitigation if he had known what mitigation was out there? Obviously, he knew his family was out there, so wouldn't that be the test?
I understand what Your Honor is asking, and I'm pointing to Farrell v. State that this court recently decided a little over a year ago. Nowhere in that opinion do I see that this court's decision that there was prejudice turned on the fact that now there's evidence he would have gone forward with this had he known. What the court says in Farrell is that whether prejudice resulted from trial counsel's failure to present the mitigating evidence. That's what the court spells out in Farrell. If this court is saying that there has to be a showing that Mr. Krawczuk would have presented the evidence had it been investigated, as I said, I certainly think the record on this case is that he would have.
Doesn't those seem like a logical analogy to how we evaluate somebody not investigating a defense for in a guilty, if you were trying to overturn the guilty plea in this case? You couldn't just say, well, there was investigation, they didn't investigate. Don't you have to show they wouldn't have pled guilty if that investigation had been done?
I can't argue with Your Honor's logic on that point. I'm simply going by what the cases from this court have done, and I don't see that reading in those cases.
Excuse me?
Yes.
Isn't it inherent in that process, in the analysis? I mean, that's just part of it. That's the whole point. The only reason this person did this is because there was ineffective assistance of counsel in investigating. I mean, is that not obvious enough that then you look to see what difference would this have made?
Sure.
And that difference is he either would have gone forward or would not have. So, I mean, it's just part and parcel of it.
And That may be what this court did, and I'm saying it is obvious also from this record and inherent from the fact that now the investigation has been done in post-conviction, and Mr. Krawczuk has allowed the presentation of that evidence, did not resist in any way. And I think also you have to look at, in this, all the circumstances of this case, this isn't a situation where Mr. Krawczuk was obstructing his counsel from investigating.
But that goes to that may go to the deficiency prong. In other words, but didn't the...
But I think I mention it, and I mention it because I think it also does go to what he would have been willing to present it had he known the information.
Now, let's go on that there were two mental experts that the original defense lawyer had hired, correct?
Two mental health experts?
Yes.
No, Your Honor, that the original trial counsel had, there was one.
And did they do a mental health examination of the defendant?
The report is unclear as to what his charge was. I think the only definitive findings that were made were that Mr. Krawczuk was competent to proceed and there was no issues of insanity. And in fact, in the record, there are motions to appoint that doctor. Specifically, trial counsel was asking for a doctor with respect to competency and sanity. His evaluation was not done with a process to extract mitigation. The information that was touched on was, as I said, touched on. It was very brief. It should have provided trial counsel with flags of information to investigate further.
Yeah, so what is it that, just give me just a picture of what did the defense lawyer actually do before the waiver of mitigation in this case?
I would say nothing. There was the competency and sanity doctor.
Did not contact any relatives?
No relatives.
And did the judge make a finding that that he obstructed? What did the judge say about the idea that it was defendant's own wishes that these people that his relatives not be contacted?
The judge actually found that Mr. Krawczuk did not unequivocally instruct her not to pursue the family history and childhood abuse mitigation.
And what was her explanation as to why she didn't?
Her explanation was she doesn't do it until closer to trial. She said that there was some indication that he was reluctant to involve family, but certainly there's no testimony that he prohibited her from doing so. She had their phone numbers. They were local. They were available to her.
If I agree, if we use the standard that he wouldn't have waived mitigation, then does that give you a new penalty phase? Or do you have to show that if the mitigation was presented, the traditional second prong of Strickland, that it would have, that the failure to present it undermines confidence in the outcome?
I think you do have to show that it undermined confidence in the outcome.
So you have to have it, so it's this two-step prong, two prongs, which is, one, he wouldn't have waived mitigation if he had known this mitigation existed, and two, that it resulted in prejudice, in that if a penalty phase with this in there would have, that it undermines confidence in what happened.
Yes, and I think certainly, I want to point out that the lower court did find that trial counsel was deficient in not investigating the family history and childhood abuse. In fact, I would argue that that's the most significant mitigation here. Mr. Krawczuk's childhood was horrific, and rather than considering the impact that that evidence may have had on the jury, the lower court discounted that mitigation evidence, simply addressing it as if he was writing a sentencing order, and gave it little weight.
You know what I still have a problem with, and I know this shouldn't enter into anything, with this incredibly unreasonable delay. This isn't about like finding new witnesses who could exonerate him. This is about what was in, you said there was a lot of public records, but this is all about having done, if you do an investigation, that should take 6 months, a year. I still can't conceive that if a certain that if he shouldn't be on death row because there's this overwhelming mitigation, that we would subject him and the system to a 17-year delay?
I mean, all I can say, Your Honor, is that from the standpoint of CCRC-South, I don't believe the record reflects that we asked for any, extensive continuances or extensions of time. I think at one point when the evidentiary hearing had been set, we asked for one continuance. I don't recall the reasons at this time.
I realize
the
that,
record would reflect that.
It's just
and
that
then,
it's hard for me. This kind of delay is absolutely unacceptable.
I understand.
And I do not understand it.
unfortunately, then, from the time of the evidentiary hearing until the order was issued was an inordinate amount of time.
How long was that?
6 years, I believe. I don't know the reasoning for that. I can't speak to that. I can only speak to that I believe CCRC-South was diligent in pursuing the claims, did investigate the claims. All I can recall is that there was some delay with public records. I don't know where that delay is attributable because I don't recall seeking extensive continuances.
Could you repeat that? It was 6 years from what?
The date from when we completed the evidentiary hearing, it was about 6 years until the lower court issued its order.
Did the same judge hear the case?
Yes, Your Honor.
And that was Judge Thompson?
Yes, Your Honor. And he was the trial judge as well.
Was he a senior judge at the time he heard the hearing?
Not at the time he heard the hearing, I don't believe. I think subsequent to that, he went on senior status.
I wanted to ask you about Judge Thompson because your first claim is that he should have been disqualified. So he apparently took the expert and he did his own research on Westlaw as to how many times this expert had testified for the plaintiff, for the defendant.
Correct.
And the first time you know about this is is it 6 years later when the order came out?
Correct. I read the order the first time I saw that he had looked at individual cases on Westlaw, compared Dr. Crown's testimony with the testimony in those cases, and then in large part discounted his credibility based on that.
And did you move for, I know you might not have this obligation, but did you move for rehearing? Is that when you moved to disqualify him?
I moved to disqualify him, and I did a motion for rehearing spelling out the impropriety of taking these actions. So I did both.
Counsel, you are now down to
Yes.
about 2 minutes.
I will reserve the rest of my time for rebuttal. Thank you.
May it please the court,
Yeah,
Steve.
it doesn't, you might want to start with, let's just start with a 6-year delay between a judge taking something under consideration. What's the state's explanation?
I have no explanation, Your Honor, except that I do believe that the judge was suffering some health problems during that period of time. I can tell you, I got assigned the case after the evidentiary hearing by about a year. I think it had been over and it was assigned to me, and I started looking at it and I realized it had been over a year since the closing arguments had been written. I did a notice of appearance and I wrote a letter to the judge saying it appears this case is ripe for your decision, and nothing came out of that. I subsequently filed 2 formal motions for the judge to rule. Again, nothing came out of that except after the second motion to rule, he did indicate to our office that he was working on the order. And then quite some time passed again, and he issued another order saying, I'm still working on the order. So it was a very lengthy delay, Your Honor. I totally agree with you.
Well, and that's just from 2006, or when was the evidentiary hearing?
04, I think, was the
04. This is what year was the death penalty imposed?
1992, I believe, is when he pled.
12 years, and it should be an embarrassment to everybody involved in this case. And it makes me then go to this first point that was raised about the disqualification. The first time that anyone knows that this judge, over the 6 years, has done his own Westlaw research to further discredit Dr. Crown is when this 100-page order comes out?
Correct, Your Honor.
And you're saying that at that point, the only remedy they have is to file a writ of prohibition?
No, Your Honor. Well, that's the case law as what...
No, it's not. The case law does it. It says if you pursue it and it's denied, but there's no case law that says that you must only pursue this by a writ of prohibition. If there is, that can't be, and it certainly can't be as to something that happens after the evidentiary hearing and at the exact time that the order comes out, where the defendant has no opportunity to rebut what the judge has just put in the order.
Right, well, we would still submit that the judge properly denied the motion to disqualify that was filed, though, Your Honor. The fact that the judge did legal research by typing in a name into Westlaw
I don't know that this is legal research. Legal research is you find cases that are on point. Finding out that you're going to further discredit an expert because you look at other cases which may or may not accurately report what he said and use that to discredit the expert, to me is, and not give, if he had done it at the time of the trial, of the evidentiary hearing, and said, listen, I've just found this about Dr. Browne, what do you have to say about that? Now, and maybe it's not a disqualification, but it seems to me a clear error that may undermine everything that the judge did in this case.
Well, Your Judge, I would disagree with you that he was discrediting him based on that legal research that he did. I think his order clearly shows the reasons why he did not find Dr. Crowne's opinion
And you don't think
credible.
that, so why did he put it in there if it had nothing to do with his assessment of Dr. Browne?
Dr. Browne testified at the evidentiary hearing that he had testified in a number of cases, and he couldn't recall whether he'd ever testified for the state. He ran his name through Westlaw, and he said basically he'd always testified for the defense, and he appeared to be a defense expert. That's it. That's
Of course,
nothing.
there's kind of a breakdown there because he could have testified in cases for the state that would not show up on Westlaw.
Correct.
So that's it's an incomplete database to reach that conclusion on, if that's...
Well, I don't think he was reaching that conclusion specifically. All he said was he termed him a defense expert, basically. And I don't think that's out of the realm of what courts do, especially appellate courts have done that in the past.
This is, to me, it's a significant issue. I don't know how it ends up impacting the case, because now that we have iPads and instant research, it is a concern that a judge, certainly legal research is different, but we wouldn't want a judge going and talking to his colleagues about, so what did you hear, what do you know about Dr. Browne, and then using that. So he's using factual information that are in cases, and he is not giving the defendant a chance to respond to it. Now, I don't know if that calls for his disqualification, but how is that, how is that not error, that we should say this is not, if this is going to be done, it has to be done where he presents it to the party, said, I've found this, and give them a chance to either explain it away or give Dr. Browne a chance to explain it away.
Well, during the questioning of Dr. Browne, in a way, it did come out, the fact as to what he testified. Granted, the judge didn't have the benefit of all of this court's opinions discussing Dr. Browne's testimony, but again, I think it falls back to what the order says, and I think if you look at the order, it's clear. Dr. Browne's opinion was discredited because he didn't review any material in this case, and his opinions were totally contrary to everything else that was in this case. It wasn't...
See, my problem, I understand what you're saying. My concern is trial judges now have computers on the bench, and let's say you're doing a FRI hearing, the state wants to bring something in, and a FRI hearing is being conducted, and there's an expert on the stand. What's to stop a trial judge from just Googling that expert and finding out all this information that the parties don't intend to introduce?
Your Honor, I don't know that there's anything to stop that.
But what if a judge did that? Would that be improper in your mind?
I don't think the trial judges should be out doing factual research outside of what's taking place in the courtroom.
When judges do that, what should be done?
Well, I think this court's addressed that situation in Vining and some other cases where it's been made part of the record as to what actually took place. Obviously, if you never know it happens, nobody's ever going to know it happened, but if the judge puts it in an order like he did in this case, then you have to review it and determine whether that would have given rise to an objectionable fear that you wouldn't get a fair hearing.
Don't we want to have a clear statement that judges should not be doing their independent factual research, factual, not legal, on the internet?
I think, Your Honor, I think that's where you get into a difficulty as to what exactly is factual and what exactly is legal.
But now, this is factual information. I mean, When you have to concede.
I would concede.
Whether this particular expert has testified for the state or for the defense, or whether he's exclusively a defense expert or not, is a factual question. Now, these cases may have some facts that you can find on Westlaw, may have some facts that are relevant to that factual question, but it's a factual question, isn't it? I mean, I don't see how you can say it's not a legal question.
No, I agree with you, Your Honor. It's also done in the sense of on Westlaw, public record, everything's there.
It's an interesting question because obviously we go to Westlaw all the time. I mean, that's just part of what we do, and we certainly do. We have to do independent legal research.
And I would note that this court has done a very similar type of thing in other cases, so has the U.S. Supreme Court in other cases.
What similar thing have we done?
Where you discussed so-and-so as an expert that's testified in other cases before us, or
Well, and I think you're right. We will say that in cases, because I've seen that same thing. Candidly, I question the propriety of that for the same reason that I'm concerned about a judge doing what the judge did here. Because it seems like to me we shouldn't go on the personal knowledge we've got about what this expert did in some other cases. But again, the parties to the case haven't had an opportunity to respond to that.
Correct, Your Honor. I find it difficult for a judge to purge his prior knowledge in that kind of situation, and I don't know how you go about doing it. Now, this is not that example. The judge actively went out and went on to Westlaw to do this. But again, when we're analyzing the specific issue of ruling on a motion of disqualification, I think if this court reviews his order, you'll see why he was discrediting Dr. Crown's opinion. It wasn't just because he had testified in other cases for the defense.
Let's go to actually the initial question I had about our standard here on the waiver of mitigation. The judge found deficiency in the investigation, and I want you to assume that we would agree there's deficiency in the investigation in not uncovering or pursuing mitigation. And let's leave out whatever he might have said, gee, I'd really rather you not contact my family. What is, under Strickland, when you have a waiver of mitigation, how is the prejudice prong looked at? Is it similar to the guilty plea? Have we mixed the two? I have to look at Farrell.
I think Shiro versus Landrigan, U.S. Supreme Court case, talks about that somewhat, where it's a very similar factual situation with a defendant not wanting to pursue mitigation. And they say basically, you can't establish prejudice if you're not going to say that you would have presented that had you known about it. So without even making that without even making that allegation or offering any proof of that, I think he fails on the prejudice prong. But I think, Your Honor, you were discussing with counsel towards the end of her argument the two-pronged approach that you first have to address, would he have actually done it? Would he have actually changed his mind and presented it? And then you also have to address, would it have made a difference, a reasonable probability.
So how do they establish that? Because it looks like Farrell does, citing to the U.S. Supreme Court case.
That's my dissent.
Oh, that's your dissent? Oh, my goodness. Okay, so let's go back. What did we say in Farrell?
Well, Farrell's a different animal. Farrell's a different case, Your Honor. Farrell is one where the trial court granted a new penalty phase, and in that case, the defendant went to trial, and his attorneys did absolutely nothing in preparation for mitigation. And this court just said the facts support the trial court's opinion to grant him a new penalty phase. There's nowhere in there where it discusses this specific question.
Well, it seems to me, though, I'll look at the majority opinion, that there's got to be, I would agree with you, that there's got to be some indication that the defendant would have done something different.
Right.
Now, in this case, I'm assuming the defendant did not testify?
No, Your Honor.
But unlike some other cases, the defendant apparently has completely now cooperated. He wants to present mitigation. Do we know that?
I think that's all speculation, Your Honor. I mean, granted, he went through an evidentiary hearing and never voiced any objection at that time, but this, as we pointed out, this is many, many years later. I think what the record shows, and I totally disagree with counsel as to what his what the direct appeal record shows at the time that he pled guilty, and then again at the penalty phase and at the Spencer hearing, he never wavered on presenting mitigation evidence there. The only reason, and it's very clear from the record, the only reason he allowed counsel to do anything was he wanted his case affirmed on appeal, and he was afraid he was handcuffing her if he didn't let her do anything.
He wanted it affirmed.
Right. He wanted the death penalty.
But he's not a volunteer. Now let me ask you this on his mental status, because that's probably the most family members, child abuse is abuse of childhood, something. What is it that was established in this record about the defendant's whole history of mental illness, IQ, the whole, everything about that?
I'd kind of like to start at the beginning with what trial counsel did, because counsel paints it as that she did nothing, which is absolutely wrong. She was appointed to this case. The very first thing she did after interviewing the client was get his military records, which included a psychiatric report from his discharge in the military. She got those. Then she made a motion to get Dr. Keown appointed to assist her in this case. She provided that military information to Dr. Keown. He then did a mental health evaluation of the defendant and gave that report to trial counsel. Trial counsel had it, provided it to the defendant.
What was the purpose of that mental health? As I understand your opponent, she is saying the purpose of that was for competency and sanity.
I will concede that that is what the motion said on the face of it at the time she filed it. That was the reason for it. She subsequently, I believe, testified that she had him there to assist her defense, and that's the way the report is worded, is I'm preparing this for you to assist you in the presentation of your case. Granted, his conclusions are going to competency and sanity, but he also discusses mitigation quite a bit.
What kind of mitigation is discussed in that report?
Well, you have his abusive childhood with his mom and his stepfather that's contained in that report. You have his military information, which is contained with his discharge and his, I guess he was AWOL or what have you, and was thrown in the brig, and that was in that report also. You have the discussion of minimal drug and barely any alcohol use.
And how was that report used at all at the penalty phase?
It was waived. It was specifically waived in the fact that they had numerous colloquies on that, because there was some, that's the one time that the defendant kind of went back and said, counsel, I want you to present this report to the jury because, again, I want my case affirmed, and I'm afraid if this court doesn't have it, it might not get affirmed. But then he subsequently decided not to present it to the jury. But the judge did, in fact, have Dr. Keown's report prior to sentencing Mr. Krawczuk. In addition, the judge also had the PSI that was performed.
Did the judge discuss it?
The judge actually found
the facts that were presented in that, the information presented in that report.
Not in depth, Your Honor. No. The judge found the statutory mitigator that he didn't have a significant prior criminal history, and I believe that was.
Is that uncontested that he didn't have a prior?
No, Your Honor. Interestingly, after the post-conviction hearing, the judge said that now, in light of all the new evidence he had, he would not find that would actually have been rejected. But at the time, the state was not. They had the PSI, which showed that he had just a very minor criminal.
Well, if in terms of again what has to be shown in this situation, is it two different prejudice? Do they have to show they would have not waived it, and that if it had been presented, it would meet the standard
that is my position, Your Honor. That is exactly what they need to show under the prejudice problem.
But if you have a situation where nothing is presented to the jury, they gave what, a 12-0 finding?
Yes.
Isn't it? It would be. Isn't it the same as if they did? Somebody just sat there and had an active penalty phase and didn't. They did nothing.
Right.
It certainly undermines confidence in the outcome.
Well, Your Honor, I think that's why the judge, she faults him for doing a sentencing order, basically, and I think that's what the judge did when he reviewed this, is reweighed everything that came in at the post-conviction as to how it would have had any kind of reasonable effect on the jury.
Well, I don't know. They can certainly say I would have still imposed the death penalty, but what the jury might have done, if you have no mitigation presented versus now there's mitigation, it's really, I think that's probably why that first prong is the most important. I think he would have to have shown There has to be something that says that he would have not waived the mitigation.
And I think, obviously, based on the record that we have from the direct appeal, it's clear that he was waiving that mitigation. He knew what was in Dr. Keown's report. He obviously knew about his own childhood and counsel indicated at the time she was willing to call Dr. Keown and another lay witness that had been friends with Krawczuk for about 10 years, and he specifically waived that. So I would submit that the trial court's order in this case properly analyzed his ineffective assistance claim on this and went through those various prongs and treated it, as Your Honor is indicating, with a two-step prejudice prong. Now, he did find deficiency as to the family only, and that was the only prong of his mitigation that he did find deficiency on, and that was based on the defendant's statements to his attorney that he didn't want his family involved. It was the judge kind of gave him the benefit of the doubt and said that was not an equivocal, hey, don't contact them type of thing. But one other point I wanted to point out, Your Honor, is going to the reasonableness of trial counsel's investigation in this case is early on in this case, Krawczuk filed a motion to discharge his attorney, and one of the reasons for that was that counsel was wanting to conduct mitigation evidence and had talked to him. There were two reasons. One was she was indicating to him that if his confession was not suppressed, it didn't look good for him, and number two was that she wanted to investigate mitigation, and that alienated the client. And I think when you're looking at what was reasonable, she started off by obtaining military records, mental health evaluation. She had a motion for a mitigation specialist prepared, and again, Krawczuk waived that when he pled guilty. So she was doing things, but she was running into resistance from her client, and that was hampering her. She indicated that she would have done quite a bit more had he not pled guilty early on into the process and waived mitigation. So I think that when this court reviews the post-conviction order, that there's evidence to support the court's conclusion that counsel was not ineffective. If there are no further questions, we'll ask this court to affirm. Thank you.
I want to clarify, since counsel just spoke about early on the motion to discharge counsel, and that was premised on some sort of falling out over her investigation of mitigation. That's completely incorrect. I understand that in the trial court, the lower court's order, he does say that there was some disagreement over mitigation, investigating mitigation. That's not what the record reflects. That's not what the record reflects when there's a hearing on counsel's motion to discharge. What counsel says at that hearing is that there was some disagreement over the motion to suppress hearing that was forthcoming, and something that he wanted her to look into, and there was a misunderstanding about it. And then she says that she was speaking to him about bifurcation and what that means in terms of witnesses and investigation, and that he took that to mean she was already finding that he was guilty, but that they would work that out. Not that there was a falling out over the investigation,
would you, as succinctly as possible, outline for us those mitigating factors that you say exist as determined, the evidence that you put on, as compared to what was known at the time these decisions were purportedly made?
Okay. There certainly now is details upon details about a very severely abusive childhood, emotionally and physically.
Was the issue of abusive childhood known at the time of the initial expert's opinion, back when the decision was made?
It was mentioned to him that the mother.
I don't want to take up all your time.
Okay.
So abuse was mentioned, but not in sufficient detail, is your view?
Not in any detail,
okay,
and there were no findings made
what
with respect to that. Okay.
What were the other items?
There certainly is the culpability of the co-defendant. There was no evidence presented with respect to the culpability. I think in addition to the culpability, there is indication of who the predominant defendant here was, and that there is now evidence that Mr. Krawczuk was more influenced by the co-defendant. There certainly is the mental health evidence of mental illness.
What evidence? The person who did the initial examinations did not know anything about and did not convey information about mental health?
He didn't make any findings in that regard.
And that's
His
findings.
report is blank on that.
Well, I thought the counsel's taking position had the psychological records from the military, so, I mean, must have something. Or is that just a misrepresentation to us?
No, they did have the military records, and she provided him with...
Did that have mental health in it? I'm trying to get, for your benefit.
It mentioned that he had a personality disorder.
Okay.
But as I said, the problem with the report from Dr. Keown is that all these things were touched on. Nothing was discussed in terms of mitigation. And in fact, the trial court said that he reviewed that report and found no non-statutory mitigation present there, because that's not what the purpose of that evaluation was.
Well,
so
again,
while this information...
we can debate all day about purpose, but there's no way you can determine competency without looking at mental health issues.
Well,
That's what you're saying is that many of these things were disclosed, but not in the detail or discussed or evaluated to the extent to make an informed decision.
Correct.
But they were disclosed.
He knew there was a personality disorder because the military records reflected that. There was no other findings. Mr. Krawczuk also has obsessive compulsive disorder, which impacts his thinking and his state of mind. The cognitive disorder that Mr. Krawczuk has, and certainly that impacted his state of mind. I think I've outlined all of this in my brief, as I know I'm running out of time.
If you have run out of time,
yeah.
but if you would sum up in 15 or 20 seconds.
I mean, certainly here that there is evidence that Mr. Krawczuk would have allowed, if this court is going to impose that burden, which I don't believe it did in Farrell v. State, and there's no way to distinguish Mr. Krawczuk's case from Farrell v. State. The prejudice here to Mr. Krawczuk is confidence is undermined in the outcome. Nothing was presented on his behalf, and now we have substantial mitigation that could have been presented. I do just very quickly want to point out that something that I think is very important to this case and important to the culpability that's considered is the noise in the background of this case here is Mr. Krawczuk's co-defendant is out. These were equally culpable co-defendants.
Well, he pled
that
guilty
evidence
to
is
second-degree
present now.
murder, didn't he?
I'm sorry?
The co-defendant pled guilty to second-degree murder.
Because I think in part because Mr. Krawczuk refused to testify and they didn't have enough evidence against him. But there is evidence of equal culpability.
Have we already crossed the bridge with regard to the charges faced by co-perpetrators?
In terms of
Have we
a
crossed
jury.
the bridge?
I'm sorry?
Have we crossed the bridge on that analysis, and we have opinions, do we not? That's not equal culpability when someone pleads to a lesser charge.
I think that what I am...
All it is
yes.
yes or no. Okay,
but what I'm referring to is the culpability that should have been presented to the jury here. And I just think that that information can't be overlooked at this point.
Not the charge and the plea, because that didn't happen until afterward, correct?
No, but there was certainly evidence of both defendants participating equally in this crime. That the participation of each defendant in causing the death of this victim cannot be separated out and attributed to one more than the other. Thank you.
We thank you both for your argument. The court will now take a 10-minute recess.
All rise. All rise. Supreme Court floor is now in session. Please be seated.
Before we go to the last case on our docket today, I wanted to acknowledge the presence of former Justice Overton and his class from the University of Florida School of Law. We're very pleased that you're with us here today. The third case and the final case today is the state of Florida versus Larry Phillips. Counsel, please proceed.
Good morning. May it please the court. Joseph Lee, Assistant Attorney General, on behalf of the petitioner of the state of Florida. For any matters not discussed here today, we would respectfully rely on our briefs on the merits. It is the state's position that pursuant to Section 394.9135, lawful custody as a matter of law for the Rights Act includes a prisoner whose discharge is immediate based on considerations such as a corrected end of sentence per matter such as credit for time served or gain time, even where the end of sentence has already expired, where the sentence was proper at its inception. We would respectfully ask this court to reverse the majority decision of the Second District Court of Appeal and answer the certified question in the affirmative.
Why didn't we already decide this in Larimore?
For several reasons, Your Honor. First, and contrary to the reasoning by the Second District, Larimore was not controlling, and respectfully, the majority opinion has misread Larimore. In Larimore, this honorable court held that an individual must be in lawful custody where the state takes steps to initiate Rights Act commitment proceedings, but in the context where the Department of Corrections sentence was improper at its inception. Therefore, there was no custody at law, which pulled Larimore's situation into a situation as espoused under State v. Atkinson, or Atkinson versus State. Larimore's entire resentencing had been unlawful at its inception pursuant to Tripp v. State. In our situation, Mr. Phillips' VOP sentence was...
But it wasn't illegal. I know we used the word. It wasn't as if they snatched Mr. Larimore off the street and held him illegally. It was a lawful sentence. It just became, because of game time, it meant that they couldn't hold him for any time in custody, right? Wasn't that Larimore? In other words, there wasn't anything wrong. The sentence wasn't, it wasn't illegally, he wasn't being illegally held in custody, was he? Illegally.
Well, in Larimore, the entire resentencing pursuant to the violation of probation had been unlawful at its inception pursuant to Tripp v. State.
But what does that mean? I mean, it just means that they didn't give him gain time that he was entitled to, right?
Respectfully, no, Your Honor. The way that the state reads this case is that because
what happened? Not what you read. What happened in Larimore? What was the error that was made? Wasn't it a game time error?
In part, Your Honor, it was a credit for time served and gain time, but the effect of it was that at the time that he was sentenced pursuant to the VOP, he never should have been incarcerated to begin with. That the credit for time served would have nullified what his incarcerated sentence would have been. So at its inception...
So how is that different from, how does that differ from this case where once you add the gain time, his sentence had expired on August 31st?
Well, both Larimore and our case deal with a trip type situation. However, the distinguishing consideration is that in Larimore, it dealt with section 394.913, subsection 3, which deals with a referral for commitment prior to the end of sentence.
It's really hard to take this statement out of Larimore, which says, as to the question of custody, we conclude that it is clear from a reading of all the related provisions that the legislative intent of the Jimmy Rice Act is that the person is in lawful custody at any time, at the time any steps are taken in the commitment process under either 394.913 or 394.9135.
However, in note 8...
have I correctly stated what that sentence read in Larimore?
I believe you have, Your Honor.
Okay, so if that's the holding of the case, how do you get around Larimore?
Well, we would refer in part to note 8 in Larimore, which states specifically that Larimore did not reach the question of whether 394.9135 Florida statutes would allow the state to take steps to initiate a commitment proceeding against a person who, while in lawful custody, obtains an order for immediate release for any reason.
Well, what could be the reasons couldn't there be other reasons that somebody is released other than that they are not in lawful custody at the time of the commitment proceedings? Can you consider, is there other reasons that somebody might be released from custody?
Other than an illegal sentence, Your Honor?
Yes.
On the other extreme of
maybe clemency?
Clemency, that's what I was just about to say, Your Honor. That's the other type of scenario that I can envision going to the executive side of government. In rough form, Larimore dealt with a situation of a different statute, 394.913. And in the part that Justice Pariente just read, we would respectfully maintain, first, that Larimore, by its plain reading, did not reach the scope of 394.9135, but it never defined lawful custody under purpose as relevant to section 394.9135.
It never, I don't know how that statement that Justice Pariente just read does not clearly say that lawful custody is a prerequisite, whether you are talking about one section or the other.
Yes, Your Honor.
Even though Larimore did not deal with the other section, it clearly says that. So just tell me how you get around that language.
Respectfully, because we're dealing with two different statutes, 394.913 and 394.9135, as a matter of legislative intent and the plain reading of 394.9135, the state would respectfully contend that lawful custody is defined differently under that statute than it would be under 394.913.
Well, let me ask you this. Do the words lawful custody, does that phrase, lawful custody, appear anywhere in the Jimmy Rice Act that you know of?
No, Your Honor.
So lawful, it talks about total confinement.
Yes, Your Honor.
That's what the statute says, right?
Total confinement and custody, yes, Your Honor.
Okay, and custody. Those are the two terms. Lawful custody is something that comes out of our case law.
Yes, Your Honor, primarily Atkinson v. State. The state would respectfully contend that Larimore, although it did not address the situation of the scope of 394.9135, actually supports indirectly, in its reasoning, the state's position in this case. In Note 4, this court in Larimore recognized the legislative intent for 394.9135 and cited and quoted Senate Bill 2192, which became 394.9135, and specifically stated that that statute was passed with the legislative intent to deal with situations where inmates successfully challenge gain time in early release statutes and win early judicially mandated release from prison.
But I can certainly understand that, because you could have a situation, you take this case, if his particular, after all the gain time was actually put lawfully correct, and his release date was, for example, December 12th. And then on December the 6th, the state could, in fact, lawfully start a commitment act under 9135 although they didn't start it back at the time period for 913, you can lawfully do it under the second statute because you still have 6 days left on his lawful confinement. So I can see what the legislature was trying to do. If, for example, you do find yourself with a short period of time, you can then proceed under that statute to have someone committed under the Jimmy Rice Act. But I don't think that translates into you can do a Jimmy Rice Act proceeding when someone is not in lawful custody.
Well, again,
so if you have that kind of situation, I think you're absolutely correct. That's what 394.9135 would do.
well, again, for purposes of 394.9135, the state would contend, as established by the language of the statute and the legislative intent, that lawful custody is defined somewhat differently than it is under 394.913.
We're going to have a couple of definitions of lawful custody.
I think that
what Justice Kennedy asked you, the term lawful custody is not in the statute. So what is the term that was interpreted in Larimore and Atkinson about custody that is different in 9135?
Well, in part, when we were at this point relying on the maxim that the courts have to interpret the statutes as to give them meaning, under the proposition just given by Justice Quince, or the hypothetical, Section 394.9135 would in effect be rendered meaningless. 394.9135.
Why would it be, under my hypothetical, why would it be meaningless if they start commitment on the 6th and his sentence doesn't expire until the 12th?
Because as established by the case law, most notably Kephart versus Hattie, with Justice Quintero concurring in Note 9, and State v. Good, under 394.913, the law is well established that although the preference under that statute, 913, is to commence rights proceedings at least 545 days prior to release, the state actually can start it up until the day that he's released. But the 545 days is at most a guideline.
You see, that's the whole problem. If they do that, they do it at their peril. If thereafter it's found that on the day that when they started their proceedings, the defendant was not in lawful custody. I mean, we're talking about somebody who was entitled to be released from a sentence, and we've upheld the Jimmy Rice Act, but only with the understanding that we've got to be very careful about the due process rights of the individual involved, and therefore the restriction that the person be in lawful custody when these proceedings are instituted is one of the due process protections that a defendant has. And if he's not in lawful custody, the state, and was never in, or it's determined that they were not in at the date, then they're entitled to release. And I'm not sure I understand why, unless the state is just going to get the benefit of saying anytime all they have to be is in custody, doesn't have to be lawful, they can just take them off the street, put them in custody, and start the clock running. We've got to be, interpreting the statute consistently.
Well, respectfully, the state is not disputing that the custody has to be lawful. What the state is contending is that as a matter of law, lawful custody, although that has been judicially imposed, concept that the lawful custody required under 394.9135 would entail a type of situation different than 394.913.
And you're relying on a concurring opinion for that?
I'm sorry, Your Honor?
Did I understand you to say you're relying on a concurring opinion in a footnote as the basis for supporting your argument?
Well, in terms of distinguishing Larimore, Your Honor, we are relying in part, not on a special concurrence, but I believe on the majority's opinion in Note 8 in Larimore, which stated that...
But you just mentioned something about a concurring opinion, footnote 4, that supports your argument. Yeah, is that...
Oh, I'm sorry, Your Honor. With regard to Justice Quintero...
Well, I'd like to know why when a concurring opinion becomes controlling for the decisions out of this court.
We're not advocating it that it's controlling. However, we're advocating it as case law support. The more definitive opinion would be State v. Good, which held by a majority of this court, if not unanimously, that under 393.913, the Rights Act proceedings should ideally start 545 days prior to release, but can be started at any time up until the actual time of release.
What is the status of this defendant?
The respondent, Your Honor?
Respondent?
I believe he's still at the Florida Civil Commitment Center.
So he has been, so the Second District granted a stay of their mandate?
Yes, Your Honor.
So we have a person who has, since 2005, and it's now 2011, been in limbo and incarcerated by the state of Florida?
Detained.
Okay.
Well, what does that mean?
Respectfully.
He's locked up, isn't he?
Yes, he is. Yes.
I mean, no one asked us to expedite. It's another thing I just don't understand is if we agree with the Second District, is he entitled to release?
Based on the Second District's reasoning, it would seem so, Your Honor. It can't.
I don't, you know.
And quite frankly, even the Second District opinion was 5 years after he should have been out of released from custody.
I mean, that may not be the state's responsibility. I just don't understand what goes on in these cases that somebody, you know, there's a legal issue and this isn't brought to our attention to expedite a case like this. Whatever way, if we decide in your favor, you know, the proceedings should have been, you know, he may not be found to be a sexually violent predator, but he's in total limbo because of the Second District granted a stay of its decision?
There was a stay of the mandate, Your Honor, yes. But with regard to, I believe there's questions in terms of delay in terms of proceeding to the trial on the merits. I would probably, Mr. Donnelly would probably be a better person to address because he was trial counsel. But the state would strongly suspect that some of the considerations as stated and discussed by the trial court in Morrell.
Does he get reviews every year to make sure, to see if he's entitled to release independently, or he is just in this limbo status?
The strongest protection for him is that he has the right to re-invoke the right to a 30-day trial at any time.
Sort of moot his appeal here, wouldn't it? He could do that and then
Found a predator.
If he's found not to be a predator, then if he's not found to be a sexually violent predator, then yes, it would seem like it would moot out this appeal.
So it seems to me that your argument here really is that anytime you're in actual custody, that's enough, whether that custody is lawful or not. I mean, that's what it really breaks down to, is if you're in actual custody, whether you should have been or not, and Jimmy Rice proceedings are commenced, that's enough to follow through with the Jimmy Rice proceeding.
Respectfully, no, Your Honor. We would contend that the state's position is that in a situation where the sentence is lawful at its inception, and that's one of the primary triggers for 394-9135, that it's lawful at its inception, and that for unexpected reasons his release becomes immediate for factors such as gain time or credit for time served, then at that point.
But that was, I mean, again, going back, but Larimore, when the sentence was imposed, it's a lawful sentence. It's just that the calculation of gain time changed whether he was going to have incarceration or not.
Yes, Your Honor, but respectfully, incarceration is one of the prerequisites under 394-913 for the Rice Act proceeding to properly commence.
If I understand you correctly, and lost me there, as long as there's lawful custody, as long as the sentence is lawful, that is all we should look at. We should not ever consider gain time, incentive, or basic. That should never be counted in the equation in determining what's a lawful sentence.
Well, the first thing that the state would contend that has to be looked at is whether the sentence was lawful at its inception.
Okay, let's say I'm the judge and I sentence you to 10 years, and that is within the sentencing guidelines. Okay? That's a lawful sentence.
Yes, Your Honor.
Right? So I could technically, you could be committed anytime within those 10 years.
Respectfully.
Despite the fact that gain time would have reduced us 10 years to maybe 6.
In that type of situation, and this is one of the reasons why we would contend that the Second District's majority opinion was flawed. On its face, what the hypothetical that you have proposed is a lawful sentence on its face.
Right.
But issues with regard to, latent issues with regard to gain time or credit for time served are rarely going to be obvious at its inception, and they're not going to be self-executing. It would require, for example, a Rule 3800 motion.
Credit for time served wouldn't it?
But
Ideally, it should be.
you're entitled to that because you've done it. But on gain time and incentive time, what I'm getting from you is that it is not a vested right in a prisoner. Gain time, incentive or basic. It is not something the prisoner is entitled to. It is something that is given to him or her.
Well, with regard to...
Because he's not entitled to it, then the only thing that should count is whatever the sentence was. Hence, my hypothetical that if you sentenced to 10 years in prison, and somewhere along the line somebody forgets to give you the gain time, as long as you're in prison for 10 years, or during the 8th year, they decide to commit you when you should have been released 2 years earlier because of gain time that wasn't given to you by accident or whatever. That's all that counts. You are in custody pursuant to a legal sentence. I think that's what you're saying. And gain time doesn't count.
Well, under 394-9135, we would contend that gain time is a factor because that's what the legislative intent made clear in terms of what that statute was supposed to address. But where it is a factor is when the award of something like gain time or credit for time served or early release judicially ordered mandate, when that trigger is pulled, then at that point, the safety net as provided under 394-9135 would kick in.
Okay, counsel, you have used almost all your time, so that means your rebuttal time is virtually gone. I will give you 2 additional minutes.
Thank you, Your
for
Honor.
rebuttal.
May it please the court, my name is Richard Donnelly. I'm an assistant public defender from Fort Myers.
Can you tell me just in representing your client?
Yes.
If the second district's opinion is approved by us,
Correct.
is he entitled to release?
He is.
So for the entire, can you also explain how the second district's case, which was decided in 2010, had that happen, how 5 years transpired between when he when he should have been released on August 31st, 2005, and their opinion of December 2010?
Judge, I've been doing this since the beginning of this act, so I can tell you that I was aware within a couple of weeks of this case being filed that Mr. Phillips had a legitimate issue in jurisdiction. Now, a lot of stuff happened after that, but as you pointed out earlier, do you rush to trial or do you make a decision?
But in terms of did you ask for us to expedite the proceedings?
Well, it was really a legal issue, so it wasn't a matter of expediting. For example, Larimore did not come down for 5 years almost.
Larimore came down in 2008. It's 3 years later.
Right, and 2009, and the end of 2008. And Larimore, when it came...
It does, you know what, we're not communicating on this. I guess it's just you're overburdened, but, you know, somebody is being held and, you know, hopefully, I don't know what, you know, do they get treatment in the 5 years or are they getting worse? It's just it's a terrible situation.
It is.
That we have here. So why don't you go on to the law?
What we have, and I think...
Can I ask you a question
Sure.
that's related to some of the things we've discussed about section 394.9135?
Right.
What is your understanding of the purpose of that statutory provision?
The purpose of the statutory provision, as reflected in the Senate Children and Family Subcommittee notes, 91 or whatever it is, 2692 or whatever it was, back when they amended this statute, which was in May, it took effect May 26th of 1999. And the reason, if you read the legislative history, which I've cited in my brief, was the, and I can tell you this anecdotally, that this happened.
Well, we've cited that history in Larimore.
Right. And what was happening is when this amendment was passed, before it was passed, and the reason it was passed is because all these people were being released, and this was a new act, and it just didn't have time to review these.
Let me ask you about what we said in footnote, what the majority said in Larimore in footnote 4, when we're in the midst of the discussion about 394.9135. We refer to the Florida Senate Committee on Children's and Family Staff Analysis, and that which stated that the section addresses situations where, and I quote, because of unforeseen circumstances, it is anticipated that a person's release from total confinement will become immediate. And it goes on to say, this section would assist in dealing with cases such as when inmates successfully challenge gain time and early release statutes, and when early judicially mandated release from prison. Why isn't that exactly what we're talking about here?
Underlying the whole issue is due process.
Well,
and this court...
That's just, I understand. Due process, you may have a due process argument, but I'm talking about what we said, what we quoted in the Larimore opinion from the staff analysis, and candidly, I'm not a big proponent of looking to legislative history, but we've got it here in this case. And what is that talking about if it's not talking about a circumstance such as the exact sort of circumstance we have before us in this case?
It is, but, Your Honor, it requires... this court has ruled in numerous cases, Larimore, Atkinson, a variety of cases, that the person must be in lawful custody at the time the case initial steps are taken in the case. In other words,
can you give me your understanding of what the majority meant in footnote 4 by quoting that language? They do not say this isn't right. They don't question it in any way. They actually start out by saying this interpretation, which some other things they've said, is confirmed by the Senate staff analysis.
Judge,
they're relying on it.
Your Honor, I'm not arguing that the words don't mean what they say, but what I am saying is that before that is constitutional and legitimate, there must be an initiation of the rights process while the individual is in lawful custody. That must come first. And under all the cases that this court has decided, you have emphasized that the person must be in lawful custody when the first steps are taken to initiate the process. Mr. Phillips, we all agree on the facts here. Mr. Phillips was in custody on August 31st of 2005, legal, lawful custody. A month later, the court determined that that was, in fact, the last day of his sentence. We all agree on that. We all agree also he sat in custody for 97 days, over 3 months, before the state did anything with regard to 9135.
There's some people sitting around on both sides of this. Doesn't Judge Alderburn actually make a pretty interesting point that the way the majority in the second district rule really allows for the great opportunity for game playing? It actually gives a perverse incentive for a defendant who knows he's going to be subject to Rights Act proceedings. He's got that kind of history, he knows that's looming there. It actually gives him an incentive to get a sentencing error of some sort or to not get a credit for something so that, and then get that corrected at a time when it's going to be too late, when he's going to be entitled to immediate release, and he'll be released at a time when his custody is not lawful, and therefore set it up to avoid the Rights Act entirely.
Judge, that's a possibility, but not in this case. The majority in Phillips addressed that. Phillips filed his motion to get trip credit for 2 years, 5 months before the end of his sentence. The state had all kinds of notice in this case that Phillips was subject to Rice proceedings. The transcript...
When was the first time that the state filed the petition? When did they file it?
December 12th of 2005.
And when was the decision that he was entitled to release in August?
Decision came out on September 30th.
So what you're saying is, even if 9135 applies, didn't they have to do something within a short time after that in September, not wait till December?
That was your position, Justice Pariente and Tanguay, in your dissent. You said in that case that they should have taken action within 5 days. And in theory, I would agree with you.
I mean, even if the legislature intends it, they can't here. The state could have moved immediately in September.
Correct.
And, I'm thinking of a provision the state could put in, like a recapture provision of an immediate, given some from that time if they want to kind of look at that, but not wait 3 months to...
If I can address one other issue in this case...
Is that correct?
Yes. And if I can address one other issue in this case, which I think is very important, is that Mr. Phillips had a VOP hearing in June of 2004, in which the transcript will refer you to Appendix U. There's all kinds of comments in there with regard to things that would have put the state on notice of the fact that he was going to be subject to rice. There was a comment by the state attorney. He was ordered into sexual predator treatment. He was designated a sexual predator. And most important in that transcript is the fact that the state attorney who represented the state of Florida was the one who caused the sentence to be erroneous. It wasn't Mr. Phillips. He's a layman. He doesn't know about trip credit. He learned about it. So the state attorney is the one who told the judge he was only entitled to 177 days credit, despite the fact that the state...
Did he have an attorney?
Yes, but his attorney didn't do very well either. But despite the fact that the same state attorney who's telling the judge he only is entitled to 177 days credit recited the fact that he had served 2 years on the original split sentence. And under Tripp, we all know that he's entitled to that on the VOP. Now, Tripp had been...
Was that discussed at the hearing, that it was either 177 or 177 plus 2 years?
No. No one... I mean, it was mentioned that that he served 2 years, but no one picked up on it. The state has argued in their brief, as the court knows, that they had a right to rely on that facially valid sentence. They had a right to rely on that when they caused the invalid sentence. They're the ones that caused it. Now, how can they turn around later and say, well, we have the right to rely?
The defense attorney had some obligation
to
say, look, this man has already served 2 years. He needs to have credit for those 2 years. So, I mean, there's some...
I agree, Justice.
Well, and in fairness to everybody involved, I mean, this is a very complicated area of the law where it changes from time to time and depends on when the offense was. And I mean,
although Tripp was in force for 12 years before the date of this VOP, I mean, after 12 years, somebody should pick up on the fact that we're supposed to give them credit.
Well, the DOC actually is the one that did it come to the attention of the DOC that he needed to get the 2 years?
Well, all of the information goes to the DOC when these people get put in prison. And the first thing the DOC would see is he has a qualifying offense for rice. Now, it's up to...
But I'm asking, who figured out the 2 years was due to him?
I guess Mr. Phillips, he's the one who did the pro se motion.
Oh, I guess was there an affidavit, though, from a warden that...
No, Mr. Phillips filed a pro se 9 or 10 months after his incarceration, pro se trip. He's a smart guy, and he presumably did some research.
So at that point, it's now, when is it that he brings his pro se motion that
April 6th of 2005, almost 5 months before the end of his sentence. So the state wants to rely on a faulty sentence they created and says we didn't have any notice of the fact, so we didn't comply with the 545 days under 913.
Well, was there a pro se motion filed on October 21, 2005?
That was after the judge had ordered the early...
and he was attempting to clarify that he was entitled to Georgia credit.
Yes, there was more time than that. He was trying to get additional credit from Georgia, so it really didn't have anything to do with the 2 years. That was already filed, and the judge ruled essentially he was entitled to the 2 years already.
So on November 8th, 2005, the post-conviction court denied the motion, treating it as a motion for rehearing.
I suspect that's true. I suspect that's true.
And nobody took any kind of an appeal from that?
No. They accepted that.
So the last judicial proceeding was on November 8th, 2005 until December 6th when the Jimmy Rice proceeding started.
Right.
Is that an alternative argument? In other words, if we accept that there's some difference or what 9.35 does versus the other, what is it requires the state to do when there's a threat of immediate release? What does the state have to do? They have to before the person's date of immediate release, or at least on that date. In other words, if a decision came down today from a circuit court and said that as of October 6th, Mr. Phillips' sentence ends, the state could initiate the Jimmy Rice proceeding on that date. Well, what I'm
but
suggesting,
they never did
though,
that.
is even in this case, even if we agree with the state that there should be some other, there's some safety valve in 9135, it seems to me that when they know that they've got to do it, don't they have to do it with, they can't wait till after the person's released, certainly. So don't they have to file something while the person is still in custody?
Well, that's not what 9135 says, is it? It says it'll be transferred over to the department, and then they have to file.
But a prerequisite to filing, as Justice Perianti pointed out in the Larimore decision, 9135 and 913 both require that the initiation of the process, the referral of Mr. Phillips to the DCF, their multidisciplinary training, must occur while he's in lawful custody. In this case, the state did nothing for a year and a half, even though they had all kinds of notice that Mr. Phillips was subject to Rice. And when he got, and they even had 5 months notice that he was trying to reduce his sentence by 2 years, which should have put them on notice.
What was his, do we know in this record what his original release date? He filed this in April of 05, his motion to get his gain time. At that point, what was his presumptive release date? Do we know?
They get any incentive gain time that they earn. They're entitled to that. They could lose it in theory, but they get that every month. They get basic gain time of about 1/3 of their total sentence. Everybody gets those things.
The answer
now,
is no. The record doesn't really say.
No, the record doesn't. But I would point out to you that available to anybody in the world 24 hours a day is a website that gives the tentative release date of every single person in the DOC. So it's not a mystery to the world. It certainly shouldn't be a mystery to the Department of Corrections.
My question was going to the fact that ideally, the state is supposed to initiate Jimmy Rice proceedings at least 565 days before a defendant is going to be released.
Or as soon as practicable.
Or out when that 565 days would have been.
Justice Quince, and it also says in that same statute that mandates that, or if it's less than 545 days, as soon as practicable.
Right, if his sentence is less than 565 days.
That's always
right.
But here's a guy that's asking his sentence to be reduced by 2 years. It seems to me the light bulb should have gone off somewhere. The state is responsible. I mean, it's their statute, and we're talking here fundamentally about a due process argument. We're talking about keeping somebody in custody for 97 days till they finally get around.
Well, we're not exactly, that's what I said, but on top of it, though, we've kept him in custody for 6 more years, which doesn't seem to bother anyone here. It bothers me, and we have another case where someone's in custody for 8 years, and I mean, this is apparently, without being adjudicated. This is, I'm sure that's not what the legislature intended to
No, I'm
happen.
sure it is not. And the issue in all of these 9135 cases, it seems to me, and it's going to continue to occur unless the departments of the state recognize they have an obligation to process these people. I mean, Good and Kephart and all these cases said, get these people processed as soon as you can.
Well, on top of it, though, since is that the idea that it's only, this game time can be tricky from, purport to be an expert in it. And to say the defendant's the one that's supposed to figure it out, maybe this is a wake-up call that the state really should be doing its due diligence at the time of the original sentencing to make sure that the sentence, the gain time, is correct, because they have now an additional incentive. We don't want a defendant to stay one more day in custody when there's gain time that's been miscalculated. And this is, so it's really on the state, not just the defendant, pro se, to make sure the gain times are accurately calculated.
We haven't addressed in this case yet the certified question that the second DCA sent to this court, which goes along with this whole issue, and that certified question, as the court knows, is does the state have jurisdiction to initiate civil commitment proceedings under the Involuntary Civil Commitment of Sexually Violent Predators Act against an inmate who is entitled to immediate release based on a corrected award of gain time? My answer, I would respectfully suggest to that, is if the state did not initiate the civil commitment procedure while the inmate was in lawful custody, the answer is no. So to answer Justice Pariente's question then is, if the state would have transferred an individual who got immediate release under 9135 and he had been referred. Now, referrals is just simply sending notice to the multidisciplinary team that this person should be reviewed. It's very simple, and that's all that's required under Bishop and under Madison, under these cases, to say that's what the referral process is. You don't have to go through the whole, you just simply have to refer them, and that stops the statute from running, essentially. It tolls the bell. But none of that was done in Phillips, and in these cases where 9135 is being invoked, the problem the state has, the state's big, it has lots of different departments. In all of these notices that were sent, like Phillips' motion to get his 2-year strip credit, he sent a copy to the same state attorney who erroneously told the judge he's not entitled to it. So the state had lots of notice that this guy's sentence was probably going to get reduced. I mean, anybody who looked at his motion and looked at Tripp would have known this is a no-brainer. He's going to get that 2 years. And so something should have been done.
Why shouldn't there be lawful custody at least to the time when all the litigation over what gain time would be concluded?
I'm sorry, Judge.
Why shouldn't there be lawful custody over someone at least to when litigation over gain time or similar issues is resolved?
Well, I think the issue of lawful custody is a question of, is there any legitimate basis to hold somebody, restrain their liberty? You know, liberty is life, liberty, and the pursuit of happiness. It's right up there. And when a person is held for 97 days without court order, without court authority, that's unlawful custody. I mean, he would have been entitled to a habeas corpus remedy at that point, which requires unlawful custody.
Well, I think what he's asking is that there's litigation ongoing in some of these things, and if you're in custody while that litigation is ongoing, as I interpret what he's asking you, is should it not then run from when it's over, rather than from whatever may be determined by something that's in dispute?
I think
that's what you need to answer.
Yes, and I think the definition of unlawful custody controls. And if somebody is in unlawful custody, that means that there's no legitimate authority to hold that person and restrain their liberty. And once that happens, under these Jimmy Rice scenarios, the issue is, has he been referred for commitment under the Rice procedure? If he has, they're fine. If they haven't done anything for months and months or years, and suddenly he gets a reduced sentence and they haven't acted, as Justice Parianti said, the risk is the state's taking that risk.
Counsel,
could I ask one question?
Oh, absolutely.
The thing that was filed, and you said, yeah, I guess it could be characterized as for rehearing. That was the respondent saying, I'm entitled to more time. There was no question about the 2-year time, correct?
There was no question in the sense that he was clearly entitled to it.
Right,
absolutely.
That's what I'm saying. I mean, that was not in continuing dispute.
But what that should have triggered on the part of the state.
What he was saying is, I'm entitled to some more time because I was in jail in Georgia?
Right.
Okay.
Well, no, because he was given that time on the original sentence under Tripp.
Okay.
Thank you.
May it please the court. In brief rebuttal, as noted in the majority opinion, and after a motion for rehearing was filed in Larimore. In Note 8, Larimore clearly does not reach the question of whether 394-9135 would apply in the scope.
The issue here, do you agree that the state did not, after they knew that the litigation stopped in September, so they knew at that point that they then wait for 3 more months?
Well, in terms of giving a proper picture in terms of what happened procedurally, the motion granting the Rule 3800 motion was, the order granting the 3800 motion was, the certificate of service reflects September 30th, 2005. The order did not grant him 2 years. It basically granted the motion and referred the calculation to the Department of Corrections.
I guess in terms of what's fair here. At that point, when that state attorney got that piece of paper in his hand, he didn't go, well, I read Judge Altenburn's dissent about who's delaying and who's this, but doesn't the state from the beginning have obligations to make sure there is a proper calculation of gain time? Isn't that as equally, as an officer of the court, to make sure that a defendant is given proper gain time?
Well, yes, the state as officers of the court would have some obligation to try to ensure it.
They're knowledgeable, and this is a pro se guy that's now raising this, and no one, anyways, we could go about the equities here. I realize it's frustrating for you. You're here as the representative of the state, and we just, we're trying to do our best to, balance liberty with threat to the society, and that's, the best we can do.
In brief form, though, although I would point out that he was represented by defense counsel at the VOP hearing. But in any regard, in Atkinson, this honorable court imputed lawful custody for the legislative intent for 394.913. In this instance, in 394.9135, there is absolutely no question what the legislative intent was. It was recognized in Note 4 of Larimore, and 3 times in the Senate bills, it clearly states over and over and over again that this statute was designed as a safety valve for situations where a prisoner's release becomes imminent due to factors such as...
It's not in the Senate bill, it's in the Senate legislative history, right?
Yes, Your Honor, in the staff analysis.
But does that necessarily contradict that it still means they got to be in lawful custody at the time that the, imminent release, but they're in lawful custody at the time the first step is taken?
No, Your Honor, and that's not the state's position.
Inconsistent?
That's not the state's position. The state's...
I understand that, but I'm saying that's not inconsistent, is it?
I'm sorry, can you rephrase the question as far as what's inconsistent?
Don't worry, you're over your time. I think what I was saying is it's consistent to say that they need a relief valve, but that there has to be lawful custody when they file that first pleading to or referral to initiate those Jimmy Rice proceedings. But obviously, because you say no, and I guess that's what we'll be deciding here.
And in brief form, we would respectfully then ask this honorable court to reverse the decision of the Second District and answer the affirmative question, answer the certified question in the affirmative. Thank you, Your Honor.
We thank you both for your argument. That concludes this session of court. The court stands adjourned.
All rise.
You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.